How could the President of India, when 356 is in operation, act on the recommendation made by Governor of Jammu and Kashmir, which governor had the status only, you'll also some decision describing as an agent of the President during 356, or some judgment to say that he acts as the President? In either of the situation, he is not the governor who has aid and advice. So for purpose of 370, and for purpose of other functions of the government, I respectfully submit there is a difference between the two. Specifically for 370, you need Council of Ministers. I'm not able to conceive of a situation where there cannot be Council of Ministers. That's the third thing. And the fourth thing, which is very important, is this, that you have applied 367 and modified it and applied it. Now for the consideration of my Lord Justice Khanna in particular, my lords have been observing. What do you think of 31D, where you apply constitutional provision with modifications and exceptions? I'm saying something else. You first applied 367 by virtue of 31D. You applied that to which provision? You applied that to subclause 3 of 370. Subclause 3 says, notwithstanding anything contained herein above. The question which immediately falls for consideration is, if you have carried out a modification in terms of 31D, but applied that modification to subclause 3, when the 3 says notwithstanding anything contained herein above, isn't that 367 modification excluded from application to subclause 3 of 370? I'll consider this aspect of the matter. When it says notwithstanding anything above would mean also any constitutional application order issued under 31D will also not apply when you want to act under subclause 3 of 370. So therefore, on that basis also it has to be faulted. So therefore, what I'm submitting is going by the basic premise, the basic principles, that this action of 272, it does two things. Best part, then the last thing which I want to submit to Lordship consideration is one more thing. This power of concurrence. I say, for your Lordship's consideration once again, in 1957, we adopted our own constitution. Prior to that, we had Constituent Assembly. As rightly said, Constituent Assembly can undo things because it is not subject to any fetter. There is no control on a Constituent Assembly because it's free to evolve and deal with its affairs. But after the Constitution was adopted on 17 November 1956, I'm submitting this. The state government comes into existence under the Constitution of Jammu and Kashmir. But at the same time, the state government is required to give its concurrence or consent under 370. I say my constitution, Jammu and Kashmir constitution, is in the nature of a limitation on the power to give concurrence after 1957. Meaning thereby, even if there was Council of Ministers in place as on today, they also could not give any concurrence, because it is subject to the limitations of the Constitution of Jammu and Kashmir. Now, what are those limitations? On the prima facie, I will show. If you also will have a look at 272. The first part says, the Constitution of India as amended from time to time shall apply, subject to the modification as follows, that is 367. Means the entire Constitution is made applicable on the so-called invalid, unconstitutional concurrence of the governor. When you do that, you are contradicting Constitution of the state. And when you are contradicting Constitution of the state, there is a limitation in your power of giving concurrence under the Constitution of the state. Meaning thereby further, that our Constitution had to stay. It had to permanently stay because the state government no longer could give its concurrence in contravention of the provisions of the Constitution of the state. That limitation will have to be read into this power of concurrence after 57. Of course, there will be provisions which don't come into conflict. For example, take the High Court. Somebody cites the example of the High Court. Now it is established under my Constitution. When you say somebody gives concurrence, the Article 215 of the Constitution of India will apply. It comes directly to conflict with my Constitution. The question is not that that is superior, I am inferior. No. The question is, did I have the power to give the concurrence for the application of 215 or any other provision of the Constitution of India? My submitted lordship says I am controlled In my concurrences now, I'm controlled in my consultation is something different that relates to instrument of accession. But in respect of application of these constitutional application order, I'm controlled today by the Constitution of Jammu and Kashmir. So therefore, on that second ground, also, I say that this 272 as well as 273 are constitutionally absolutely invalid. Now, my lords, observe that, okay, you are still in history, let us progress further. Isn't this COs issued 54 in number from time to time? It was not a step in right direction. I put it to myself. It was getting closer and closer. What made you to do it on 5th August? It is not still forthcoming. And there is something more to it also. You also may recall, I said, when this concurrence is given by the government, this Governor Jammu and Kashmir, as stated in the text of 272 order. When was that concurrence given? Who gave that concurrence? What was the nature of concurrence? No material that is concealed from this court. No material is produced before the court. It is not in their affidavits. Despite having been stated in the petition that, look here, we want to know who gave this concurrence. What is the date of that concurrence? Who signed that concurrence? Was it done 1 day before? Was it done 10 years before? Who gave that concurrence? We are entitled to know it. This court is entitled to know it. There is no material on that basis. So therefore, that apart. But further than somebody says that we have given the concurrence, it doesn't look legitimate. It doesn't look sustainable. It looks all against the Constitution itself. Then lastly, I would like to submit, many statements were made here. Insofar as the development is concerned, I have only one thing to say to our learned friend, Solicitor General of India. They say self-governance is better than good governance. That's all I can tell him. Give us our self-governance back. That's number one. Number two, somebody also said it here, is very important. Nation has to grow. We can't waste our time. We want to have a unified nation. Of course, very noble thought, very good thought. But then for that, you have to win over the hearts of the people. You cannot form a nation by force, by compulsion. Win the hearts of the people. If your lordship decided this matter in favor of the petitioners, your lordship will be going a long way in winning over the hearts of the people of Jammu and Kashmir. So when the Constitution itself was being debated, that's again historical fact, what happened in the Constituent Assembly, who said what, may not be relevant, but ultimately the decision of the Constituent Assembly was this, that need to have Article 370 for state of Jammu and Kashmir. To me, this decision appears to be the most significant and important because it answers several other questions. Why for Jammu and Kashmir? Why can't we remove it today in 2023? What is so great about Jammu and Kashmir? If it is a part of India, why should it have a separate constitution? Why should it have a separate flag? Why should the President of India have to concur or consult in the matter of application of laws? These questions are answered by the Constituent Assembly itself, by the debates of the Constituent Assembly itself, and by the very existence of Article 370 as well as very existence of the Constitution of Jammu and Kashmir. Now, this is a fact of history. None of us can alter this fact of history. That is, in my opinion, the premises of this case. And as we proceed further, we find that this basic premise has continued over the years. Now, it's a separate question whether it can be done away with. And if so, in what method? By what procedures? By what process? That's a separate question altogether. The first is, as I would submit for lordship's consideration, this fundamental premise that the state of Jammu and Kashmir was different, Union of India was different. They agreed to join hands, but on certain conditions, which conditions came to be incorporated in terms of initial instrument accession, set later on by the Constitution of Jammu and Kashmir, as well as by the Constitution of India. Now, well, there was another factor, that was the matter went to United Nations and resolutions were passed. Those are also parts of your lordship's Constituent Assembly debates. Well, these matters were pending. The issue is this, that state of Jammu and Kashmir and Union of India agree so far as the integration. When I'm using this word integration, I mean in the sense of Article 1 of the Constitution of India, as well as Section 3 of the state of Jammu and Kashmir. While that stays, but I, the state of Jammu and Kashmir, should have the power to regulate my own affairs accept what I have given to you. This is what I'm conditioned to that. So in this form of taxation, I gave you something. I gave you defense, foreign affairs, and communication. I gave it to you, make laws for it. But for remaining, I will make my own laws. Now, this was the position in 1950. If I put it differently, I had the ocean of, now later on today we call it now constitutional autonomy. Ocean of autonomy available to me in 1950. This is also a fact of history and an important premise in this case, that this position is accepted both by the Union of India as well as by the people of Jammu and Kashmir. I would also like to say something.
I just wanted to point out, look, we have referred to the history, we have looked at the counter viewpoints.
The premises only.
But the fact of the matter is, ultimately, when the constitutional document is drafted and adopted and applied by the people of India, and we, the people of India, include the people of J&K, they're not separate from them.
Yes.
We are part. They will be, obviously, in people of India, there will be people from Punjab, there will be people from Gujarat, there will be people from J&K. Now, the only issue, that may not really be, because we have moved with the passage of time. We have to move with the passage of time.
We have moved. That's what I'm saying. I'm coming to that. Yes, I understand.
And now the question today is, really speaking, is the second part, which is Article 370, which is the main constitutional challenge before us. So let's confine ourselves to that.
What initially we were promised, I just look at it from another perspective, and the people who like to know that. What initially was promised was, we'll put in sort accession to a referendum. It was not done. They told us, not people of Jammu and Kashmir. It was Governor General's letter. They took the matter to United Nations. They said, go for plebiscite. It is not done. Now, after that, this constitutional autonomy was left all these years. But in 2019, that is also taken away. Who has lived up to his commitment? The great leaders of India, Jawaharlal Nehru and Patel, they were statesmen. They were not politicians. They made these commitments to the people of the state of Jammu and Kashmir. It is in parliamentary debates. It is outside the parliament. It is everywhere. But now today, since there are no statesmen left, we have politicians. Decisions have been taken. People feel betrayed. That's all I can say. Thank you.